I was walking up the East Coast Sea, I saw a big city there in front of me. So many lights and shiver up my spine, that sure had a pretty skyline. Hey friend, what's that town called? New York City.
Good day, everybody. Gary Fielder here from Denver, Colorado, reporting on our class action lawsuit, which is now in the appellate court. This week, I'll be spending a lot of time on an opening brief with regard to the sanctions that the court has imposed upon myself and co-counsel Ernie Walker. It's disappointing because anytime you have to write a brief to the 10th Circuit, first of all, it's a big deal. And you start writing and it gets pretty lengthy just by the nature of it. In fact, instead of trying to write more by the due date, you're often spending a lot of time trying to cut it down to the word count. And so sometimes these briefs can be 50 pages long, and that's relatively common. So in that regard, it's not going to be a pleasurable week. And it really interferes with my practice. It interferes with my mental state. It interferes with my family. It interferes with my ability to do my job with regard to the class action, the appeal itself, and just my attitude in general. It's been a long ride and a long road. And in the end, I guess what we're finding out is that that's pretty common. Lawyers being attacked because they're trying to support the rights of others. And I've tried to withhold my criticism of other lawyers and the lawsuits that preceded the lawsuit that we filed, because I haven't wanted to criticize other people for doing something that in the moment I'm sure they felt was right. And I understand all of the efforts made by those in the Thomas More Society that have filed their lawsuits for injunctive relief in state courts and federal courts with regard to the activities of Center for Tech and Civic Life, who we call CTCL. And I understand their approach is to get out the information and often go to court suing official government persons in their capacity as mayor, governor, secretary of state, whatever the case may be, trying to restrict funding, trying to get this out to the people that it shouldn't be happening in the way that it is. Legislatures such as Wisconsin appointing special counsel to investigate, preparing bills to withdraw a state's electoral votes, all of these things which will likely never pass, but they exist in time and space. The resolution that was created in Wisconsin, you can just read it all out, and it's all about CTCL. It's all about the money that was used by the municipalities and by the states, and it's all what the other pleadings, many of which were filed by Phil Klein and his group, the Thomas More Society, and many of which have not been successful, but that's not really the point. The point is, when you read the complaints, they have affidavits attached. They're getting the information out. I likely wouldn't have filed the case had former U.S. Attorney Sidney Powell not at least put the information out there. Now, the criticism comes from, not me personally, but due to the fact that the request for relief was extraordinary. And any time you go to a court asking for an injunction, That's called extraordinary relief. That's just a term of art, extraordinary relief. And so you have to have the evidence at the moment. In order to get that TRO, in order to get that preliminary injunction, the court is issuing an order to prohibit conduct. Well, in those cases, as I've said dozens of times, federal district courts were being asked to issue orders to stop sovereign states or to interact with sovereign states or to modify what a sovereign state was doing. That is extraordinary relief. Now, it could get so bad, obviously, that maybe a federal judge sticks his or her neck out and says, I'm issuing a show cause citation, or I'm issuing a TRO, or we're setting this for hearing. But in those situations, it really wasn't enough. It truly wasn't enough. And with regard to Attorney Lynn Wood, I remember him saying in an interview previous to the dismissal of his lawsuit that he felt better about that lawsuit than any other lawsuit that he had ever filed. But when he filed his lawsuit, he sued Brad Raffensperger in his official capacity. Probably said that about 50 times in our videos. Having done so, he didn't sue Mr. Raffensperger. He sued State of Georgia. And he sued for injunctive relief. And he made a generalized grievance about how State of Georgia, all caps, corporation State of Georgia, conducted itself throughout the process of changing the election rules, allowing for all these drop boxes, all of which was coordinated by CTCL. CTCL was everywhere. They weren't just in Wisconsin, they were everywhere. So when he did that, he was first of all asking for extraordinary relief. He was second of all just essentially griping about the government's conduct, and he was suing a state. However, he attached evidence, and he attached affidavits and expert reports. Well, anybody could come along and read those and say, well, you know what? Maybe they did it wrong, and of course, I'm sorry, I've had to now do the research on Rule 11, which I already knew before, but if you put your signature on a document, you put your signature on a document. It's a big deal. And as a lawyer, everybody knows that. So when I put my signature on the complaint, in the amended complaint, I vouched for it. When co-counsel Ernest Walker put his signature on the complaint and the amended complaint, he vouched for it, and we vouched for one another. We were checking one another. That's why there were two of us, not just one of us. You can't say that no reasonable lawyer wouldn't have filed the case because Ernie's a reasonable lawyer and he was willing to file the case, and I'm a reasonable lawyer and I was willing to file the case. So, of course, a reasonable lawyer could look at all this evidence and say, well, I'm not sure if I want to traipse off to federal court and ask them to stop the count. No, I think we'll just sue those responsible, even if it's for $1. And that might sound silly, but that's how the Constitution is enforced. That's why the injury in fact can be as little as $1. And if you just let it slide, well, who's that on? The statute of limitations runs here in about 8 months. Once it hits November 4th of 2022, which is in about 8 months, the statute runs on all this conduct. Because we're not just filing a grievance saying, hey, you did that wrong, or what you did over those 8 months preceding the election, I don't really like what you did. That's lack of standing, lack of evidence for extraordinary relief, lack of injury in fact. Because the injury in fact for us, for our lawsuit, was the 2020 presidential election. So that's where we derive our standing. That was the injury. I'm afraid that the 10th Circuit is going to deny our appeal. Of course we want to win. Of course, if the people don't have standing to sue these entities for the damage that they created, that you're suffering right now, this very second, tell me you're not suffering as a registered voter looking at your system going, oh my God, what's happening? No, tell me you're not being damaged at this very moment, and that your right to vote for president was really secured. So no, when these entities act in the way that they do, and they interfere with, they manipulate, they create a situation which casts doubt on the results, that causes an impact. And the impact is sometimes lawyers disagree with how to file certain cases, but you can bet that one of the impacts is going to be lawyers filing cases. So in the end, really, when Linwood allowed his signature to be placed on certain pleadings, he signed up, and he can't gripe now. So that's what we all do. And you could say, well, I just thought if you needed a trial attorney. Well, you should have waited for the trial. But once you put your name on a document, then you gotta, I respond. I'm filing my own brief. I file my own pleadings. I'm sure people can stay up at night and type their own pleadings if they have to. So I feel for Mr. Wood, but I don't agree with the lawsuits that they filed. But I read all the affidavits that were attached. I saw all the information. I could see it laid out before me. I could tell what was going on. I'd been following it. So I knew exactly what had taken place. And I knew that the people had standing, and I knew who at least the top culprits were. So we filed our lawsuit. And now we've been lumped in with Linwood, Sidney Powell. Every time the judge issues an order sanctioning us or imposing attorney's fees or denying our motion, and we wind up in this worldwide media, those names are mentioned in the news articles. And that's okay. I mean, that might be the subject of a libel and slander suit filed by me, which I can file pro se, by the way. If I lose my law license over this, I can still file pro se complaints against the people who have violated my rights now over the last 13 months. Because that's when we started getting these Rule 11 letters. And Rule 11 says you can't sign a pleading unless you vouch for it. Well, just look at the complaint and look at the amended complaint. Look at the way it's formatted. Look at the words. Look at the jurisdiction. Look at the parties. Look at the allegations. Look at the causes of action. I don't know where you could find a frivolous word. I don't know where any of this is coming from. All I know is that I'm going to have to spend the next 5 days filing a brief with everything personally on the line for Mr. Walker and I. Without the opinion from the substantive matter, I'm not really sure how to write that brief, other than to just say, well, of course we weren't frivolous. Of course we had standing. Of course we were just coming to court to represent our clients, to try to do our best, to try to stop this injustice. And that's really why neither Linwood nor Sidney Powell should be found to have been frivolous. They did it for all the right reasons. They thought they were just protecting their country. I don't think that they filed it for some nefarious reason. I think they were doing their best. And they had law licenses. And people looked to them for relief. And people were coming to them and saying, what should we do? And here's some information. And I viewed it one way, and they viewed it another way. And the fact that they filed their petitions and they filed their cases and got denied, well, they did their best. But in the end, as I've said multiple times, the Electoral College met and they voted. And that's on the state legislators. That's on the legislative bodies of the state. So that's on each person, it's on each legislator but it's on the legislation, the legislator, the legislature, the whole thing, the whole body of Georgia, Pennsylvania, Michigan, Wisconsin, Arizona. They sent the electors. Some tried to do an investigation. We were reading all of that. We were watching all of that. But in the end, they sent the electors, and the electors voted. But now, as we speak, here in the middle of March 2022, we are in a severe constitutional crisis. Even if President Joe Biden was elected and is the president, he is incompetent. He must be removed pursuant to the 25th Amendment. There is no choice. We are on the precipice of world war, exactly like we outlined in our complaint and in our amended complaint, because any person with two eyes could see it. Any person could just look at what was happening and say, well, in about a year or so, we're going to be right on the precipice of world war. Because they got their candidate in, he became the commander-in-chief, and now, watch, we'll be in a world war here just very shortly. And here we are. So how could we have been so wise? How could we have known that a year ago when we filed the amended complaint? Almost a year to the date since we filed the amended complaint. How could we have been so smart? Well, we weren't smart. It was obvious. You could just look at the record and say, well, here's how Facebook interacted with the election. Here's what Mark Zuckerberg did. Here's what Priscilla Chan did. Here's what Brad Raffensperger did. Here's what Gretchen Whitmire did. Here's what Kathy Bokvar did. It was all laid out in the record. Well, those are individuals. They were acting under color of official authority, but we didn't sue any states. And yet, in 5 days, 6 days, I've got to file an opening brief with regard to the sanctions which were imposed against me and Mr. Walker, wherein we have to pay the attorney's fees of the state of Pennsylvania, or Commonwealth of Pennsylvania, all caps, Commonwealth of Pennsylvania. No, we owe their attorney's fees. And, of course, State of Michigan, all caps, State of Michigan, we owe their attorney's fees too. The states were never involved in our lawsuit. From the very beginning, we had a telephone conference. We said in the telephone conference, well, why are you even here? Why are you here? You know, well, we're here because you sued the governor. No, we didn't. We sued his personage. We sued him in an individual capacity. What gave him the right to violate all of our constitutional rights? He took an oath, and when he took an oath, he swore to abide by the United States Constitution and the Constitution of the Commonwealth of Pennsylvania. So he took an oath to both. So the governor of Georgia, he's not the governor of Georgia. It's what's his name? Brian Kemp. Brian Kemp. I mean, it's Mr. Kemp. What gave him the right to violate everybody's rights? And he violated everybody's rights. So we're not suing the governor in his official capacity. We're suing Mr. Kemp. We're not suing Brian. Brian's who you see in the locker room. I've said this 1,000 times. Brian sits in his living room with his family watching TV. But when he steps outside and he becomes a professional, gets in his car, goes down to work, well, becomes Mr. Kemp. If he stayed at 7-Eleven and was on the private side, or at Starbucks and stayed on the private side, well, then he would not have to abide by the Constitution. But once he became an officer and was exercising authority under color of that official authority, well, then he had to abide by the Constitution of not only state of Georgia, but United States of America, all caps, United States of America. He had to stand by that Constitution as well. And if he didn't, well, he wasn't just affecting the people in Georgia, he was affecting everybody across the country. But somehow that's frivolous. Somehow, suing the individuals actually responsible for the position that we're in now, which can't be the state of Georgia. They acted in the way that they acted. Their voters can vote a whole new legislature in if they want to. But they acted how they acted. But our current president is not competent. He's not competent, and the vice president isn't qualified. So say hello to your new president, President Nancy Pelosi. Goodness bless her. And if for some reason she doesn't accept the appointment or is otherwise disqualified, it goes to the president pro tempore, which is the senator from Vermont, Patrick Leahy. He's a Democrat. He looks like a good person, but he's 82 years old as well. Behind that is the Secretary of State. Well, he's a dual citizen, so he can't be president. Behind that is the
Secretary of the Treasury.
Secretary of the Treasury, Janet Yellen. I think she's a dual citizen. So we're in a real crisis here. And this is all going to be breaking down in the next 30 to 60 days because he's not competent. And then once it gets to that line of secession thereafter, that's where things could potentially break down. And even if we get our elections shored up, we won't be able to vote our way out of this. Something else will have to occur, nonviolent, of course. So let's take a little break and have a message from our sponsor, and we'll be right back for a closing 10 minutes. Thank you.
A message from Save Our Suffrage. As you might remember, we are a 501c4 nonprofit organization, also doing business as Dominion Class Action, which was founded by plaintiffs and supporters like you. I speak for the team when I say that we are proud to bring you the Fielder Principle podcast and to share with you a message of peace, hope, and unity for the nation. It is all of our duties to respond to these attacks on our nation by peacefully advocating through the courts and legislatures for your constitutional right to vote, to organize grassroots activism, to peacefully defend every voter's civil rights, and to further educate and empower yourselves and every citizen of this great nation with the tools of justice and peace that each of us require to save our suffrage. We are extremely grateful for the continued support from you and so many other people who believe in working towards a fair and honest society where every vote is respected and treated equally under the law. Thank you for hanging in there with us. We will keep you posted as we continue this important work to save our suffrage and the work of Dominion Class Action. To all my fellow American heroes, the age of freedom has just begun. Be at peace.
Thank you. As I was saying, this is serious. And again, it was really foreseeable. I can't tell you what's going to happen over the next 6 months before the election. I can't give you legal advice. Even if you're a client, you can call me on the phone or you can come in and chat with me here in my office and I will give you legal advice. But generally speaking, on these types of videos, I wouldn't give anyone legal advice. I can't give you investment advice. I can't give you personal advice or survival advice. But I can look at a situation from a historical context. We're not the news. We don't try to make the news. We don't try to report on the news. What we try to do is update everybody on our lawsuit because we truly believe that the people have the ability to go to court, and they often do. And there's been example after example of how class action lawsuits have been filed against tobacco manufacturers, Roundup, other environmental catastrophes. So we understand the power of the class. One of our legal theories in regards to our class action is that the products used by Dominion Voting Systems, Inc. are defective. So it's not really a products liability case, it's a civil rights case. But the theory is that through their defective products, people haven't fallen off a ladder, they've had their voting rights burdened or compromised. So that's the theory. So we don't have to pursue the case under a products liability theory. We're using Title 42, Section 1983, because they're state actors interacting with our presidential voting rights, having done so not in a general way, but in a specific way, on a specific election, and they use defective products. And the continued use of these defective products is going to continue the constitutional right violations. Well, recently, here in the state of Colorado, one of the county clerks, Tina Peter from Mesa County, was arrested and charged with several felony counts involving her involvement in trying to capture information from the hard drives associated with the Dominion voting systems that were being used in Mesa County. And I don't know Ms. Peters, and I haven't talked to her, but I have reviewed the indictment, and they've essentially charged her with attempt to influence a public official. And I understand that some of our staff have chatted with her, and she's been quite open publicly about her involvement in this situation. And of course I read the indictment, which includes a factual scenario. It can be found on the internet. And apparently, if you were to believe the indictment, Ms. Peters made a thoughtful process with her assistant in capturing the data before it was erased through what the state is calling a trusted build, which essentially, according to Ms. Peters, as I understand it, wiped the hard drives of the information regarding the previous elections. So she felt, I'm not speaking for her, I'm just assuming that as a part of her defense, she felt like she had to do it. She felt obligated to do it. And so when you look at the statute, and it's found at 18 CRS 1880306, attempt to influence a public official. Any person who attempts to influence any public servant by means of deceit or by threat of violence or economic reprisal against any person or property with the intent thereby to alter or affect the public servant's decision, vote, opinion, or action concerning any matter which is to be considered or performed by him or her or the agency or body of which he or she is a member, commits a class 4 felony. So I've tried cases involving allegations of attempt to influence a public official. And so if it's not by threat, and that's the classic way, hey, listen, you better vote this way, you're not going to like it. That's by threat. By economic reprisal, it's kind of like blackmail. But by deceit, that's always a little difficult, because deceit infers deceitfulness. It infers evil. It infers that you're trying to do harm, that you're really up to no good. You know, deceit. So when Tina Peters did what she did, whatever she did, and you can read in the synopsis that there was some subterfuge going on, if you're to believe the Attorney General. And make no mistake about it, this case was brought by the Mesa County District Attorney and the Attorney General. So this is the state of Colorado, all caps, state of Colorado, appointing as a special prosecutor, you can look at it on the first page of the indictment, Robert Shapiro, fine lawyer, prosecutor from the state Attorney General's office. So he's working in cooperation with the Mesa County DA. And if you've ever been in court in Mesa County and dealt with that DA's office, well, then you know what I'm talking about. It's not that easy. They are prosecutors, there's no doubt about that. And so they've outlined all of these charges identity theft, several attempts to influence a public official, so on and so forth. And so I can't tell her what to do, or I can't really give her legal advice, but just generally speaking, as a sociologist, I can comment on what I'm seeing. And I would anticipate that she's going to say that her actions were justified. And that's the basis of the whole system. I mean, you can murder somebody, you can intend to kill somebody with malice aforethought, because it doesn't take a lot of time to develop that malice. But if it's in self-defense or the defense of others, well then, you're justified in committing the elements of the offense. So, if she had a choice of evils, and I've been there, I'm not talking about it, I've been there. I've tried 110 count indictments with the state Colorado Attorney General and their team on the other side, having reviewed a warehouse full of discovery and having the jury read off about 106 not guilties, but 4 guilties, a couple of F5s, but nonetheless 4 felonies. So this is what they do. They put a lot of charges in. They come out, and in that case, this is, you know, I'm not trying to embarrass anybody. It's public record. It's People v. Brown, Weld County. Same thing, $500,000 bond. My clients were arrested, and the same thing. We got a bond reduction, and so, you know, Ms. Peters gets arrested, $500,000 cash only bond. That's the state attorney general. Now, they could have just called her and said, "Hey, Tina, can you come down and sign this $5,000 PR bond? I'm sure you're not going anywhere." Oh, no. They have her arrested, $500,000 cash bond. So, of course, the judge, you know, is going to reduce that, and did, and I'm sure she's out now. But in the end, she has truth on her side. The bottom line was, she was either going to capture that information or it was going to be erased. And as I've said many times, what about O'Rourke v. Dominion voting machines? You know, that class action lawsuit against Dominion voting machines. Why are they destroying evidence? Not just for purposes of the elections that they're not supposed to do, but for purposes of this lawsuit. How can they just so brazenly destroy information when we haven't lost yet? You would think that the 10th Circuit is going to give us relief and say, well, of course the people have standing to bring their claims, but I don't know. I don't know. They can avoid the whole topic. They can say we didn't do this or say we didn't do that. We'll just have to see what they say, because in the end we're going to the Supreme Court after that anyways. Somebody is. Even if we win, the defendants are going to go to the Supreme Court. So that issue is going to be ongoing. Ms. Peters, now out of custody, is going to be going through a series of pretrial hearings. Typically speaking, I think these are a bunch of F4s. I'm pretty sure they're not preliminary hearing eligible. If you have an F3, they have F1, F2, down to F6. F1's first degree murder, F2's attempted murder, kidnapping, F3's serious felonies, first degree assault, F4's serious felonies, but just that sort of line of demarcation between getting a preliminary hearing or not. So she'll probably go to court with a lawyer, set it for arraignment, maybe continue the arraignment. There has to be plea negotiations. And if you're really going to fall on the sword, which I've done many times, if you're really going to fall on the sword and just say, I had to do it, I had to protect the country, I had to release the information, sometimes you just take the sword. So how could you blame her if she took a plea? How could you say, oh my God, I think, you know what she did, she should stick in there the whole way. Well, it's not you. It's not you in front of the jury. It's not you putting it all on the line. And there'll be a lot of pressure. And I'll guarantee you the Attorney General is going to be asking for jail time. He's going to be asking for some kind of prison time. You know, threatening our democracy, threatening the foundations of our voting system. You know, and if she dares plead guilty to one count, she's admitting to it all. See, that's the problem with pleading guilties. Once you say, I'm guilty, Judge, well, then you admit to it all. You can say, well, I know my lawyer just told me it's a good deal, but in the end, here's what really happened. You pled guilty. You did it all. Everything they said you did, you did. And you did it deceitfully. So all the information that you obtained by deceit, well, that can't be used, of course. That was gained by deceit. So that's going to go on for a while, and that's going to go on and well past the election. There's no way they're going to have a jury trial in Mesa County before November of this year. Even if we get found to be frivolous by the 10th Circuit, we're going to appeal. So that's not going to have resolved itself. I'm not really aware of any other mechanism that's going to change anything or do anything before November of this year. Meaning, it's going to be another Dominion election. And since we can count on something happening, mail-in balloting is going to continue. And I don't doubt that there'll be some need for some charitable organizations to get out the vote, or to protect the citizenry, or to pass out handkerchiefs, or to make sure everyone's protected, and just try to do good in the world. So that's probably going to happen next November too. And even though obviously it's going to be an overwhelming vote one way, it doesn't mean that that'll be reflected in the final counts. But what I'm telling you as a lawyer, as a citizen, as a father, as just a person on this earth, the President of the United States is not capable of continuing in office. And this is going to cause a constitutional crisis and a vacuum of power. And this is what the communists do. So it isn't really about secession. It's not really about the Supreme Court coming in. It's not really about a process that, if left to our own devices, we would just do whatever we need to do. No. This is how the communists operate. This is how they do it. This is how they create confusion. This is how they create division. This is how they create conflict. Because once it starts to break down that line of secession, I can only imagine. And of course, we'll have nothing to do with it. We're just going to be home protecting our families. But we cannot account for the effrontery of others. And things will get serious. So in the end, I just want you to remember, when the communists make their move, and they will, they don't play. They don't mess around. And that's what history tells us. I just want to tell a story because it's just kind of a funny one. When I was in high school, I lived in a place called Eagle River, Alaska. And it's just north of Anchorage. And if you lived in Eagle River back in the day, you went to Chukiak High School. So I got this program. Back in '79, the old Chukiak Mustangs, man, we had a heck of a team. We had these big old boys. They went both ways. We had a great quarterback. He was all-conference quarterback. And I played on the team. This is a long time ago, but we lost the first 2 games, and we tied the 3rd game. So this great team was 0-2-1. But then we won 5 games in a row. We had a pretty good team that year at Chukiak. Well, just imagine Chukiak High School against the Green Bay Packers. Would you even take the field? What would it look like? Let's say they really wanted to play and really wanted to score a couple of 100 points. Would it be 275-0? After a while, the coach would just say, hey, get on the bus, guys. Come on, we got to go. Just get off the field. And then what would they do? Would they have to finish the game or whatever? I don't know. But that's what we're talking about. When we're talking about the so-called New World Order against us, the people, it's like the Green Bay Packers against the Chukiak Mustangs. Boy, we had a good team that year. Some big old boys up front. But what would that look like? Because that's what we're talking about. We're talking about the Green Bay Packers against the Chukiak Mustangs. And we're the Chukiak Mustangs. So in the end, I don't use fear. I try not to be a negative person. But I've read all the books. I know a thing or two about history. They go house to house. That's what they do. They go house to house. They destroy constitutions. This isn't about, well, what are we going to do here in this constitutional crisis? Or what are the rules here? Or how do we structure this? No, they destroy the structure. They create confusion and chaos. And once that vacuum of power exists, they move in and they take over the means of power. And instead of a benevolent dictatorship, you know, I don't even have to tell you, you know, they go house to house. So that's what we're facing, ladies and gentlemen. That's really what we're facing. Well, boys, we better get on the bus. We better just go home and get off this football field because we can't compete against these people. Let's just get out of here. That's the only answer. So in the end, pray for us. I don't know what else to say. The decision's going to be coming out here any day now, and we're going to be working on this opening brief with regard to the sanctions that have been imposed upon us. And we thank you for those of you that listen to these videos and support us in the ways that you can. We really appreciate it, and we're going to keep fighting for you. So hang in there, everybody, and we'll be making these weekly podcasts and updating everybody on the situation. We really appreciate it, and thank you.
And it's there I'll stay and shall persist till the world sees this injustice. Power to the people I will lament. The bank should not run the government. Yeah, I better be prepared to stay there for a while. This machine